Good morning. Welcome to day 4 of our hearing. Before we continue with the examination of Ms. Chapuis, do the parties have any housekeeping matters to address?
Good morning, members of the tribunal. Nothing from claimant's side.
Nothing on our end either. Thank you, Madam President.
Then I hand over to you for further cross-examination.
Thank you very much. Good morning, Ms. Chapuis. Can we look at tab 30 of your binder, which is CWS 5, Mr. Davenport's first witness statement? And if we can look at paragraph 38. The first sentence, he says, we were also aware that Cesar Polo, who then served as Vice Minister of Mines, expressed doubt about whether the stability agreement would apply to the concentrator. Do you see that? Can you repeat your answer? My question was, do you see that?
Yes, I'm reading it.
Can we turn to tab 14? CWS 11, Ms. Torreblanca's first witness statement. And we'll be looking at paragraph 25. And in the middle of that paragraph, 25, in the middle of that paragraph, she says around the same time, beginning in the 4th line, I remember that Vice Minister of Mines Cesar Polo had expressed doubts about whether the stability agreement would actually apply to our investment in the concentrator. So my question to you is, did you know at the time that Vice Minister Polo had expressed those doubts to Cerro Verde?
No.
No.
Thank you. And indeed, I think in your direct examination, which is the transcript of yesterday, in English, it's page 837 at line 22. I'll read it to you and we'll show it on the screen. You were asked, it begins on page 837, last line, the question, do you have any recollection as to whether at that time Mr. Polo mentioned that the scope of stability would be limited to an investment project? And you said what you told me today. You said, no, never. He never mentioned that. And then you added, moreover, had he mentioned it, I would have told him, you're crazy, you're totally wrong, that's impossible. You see that, don't you?
See?
Okay.
Yes.
Now, let us look at your first witness statement, paragraph 53. And you say, beginning in line 5, Vice Minister Polo. Vice Minister Polo had a different view and was generally against Cerro Verde not paying royalties for its concentrator operations. Do you see that?
Sí.
Yes.
That Vice Minister Polo had a different view against Cerro Verde not paying royalties for the concentrator operations. Isn't that right?
Como lo dije en
As I mentioned at the Sumitomo hearing in February, I did not attend the meetings on the royalties with the participation of Mr. Polo, Sassi, and Tobar. These comments were known to me because of third-party comments, but he never told me directly to me something in this regard. At the meetings we had, my working team with engineers and attorneys, we had the participation of Engineer Tobar, and he never presented any objection to the ones in attendance with any decision, and we always had consensus. Had he told me that, if he had told me that, if Mr. Polo or Mr. Tobar had told me that, we would have analyzed together the regulations, and in those 10 years when I was or myself or Mr. Polo were not there, we would have seen the list of contracts signed, and we would have seen the criterion. I would have seen that this is the criterion, and for me, from the mining point of view, it is correct. As DGM, I am going to act based on the consensus of my group of attorneys and engineers.
You did not attend the meetings in the ministry about royalties. You learned of Mr. Polo's views from third persons, and you mentioned that you discussed that in February, so let us look at your testimony at the February hearing. And I ask that we look at tab 6, which is C1135, day 3 at page 895 in the English.
Disculpe, ¿cuál es el número de la página?
I apologize, what is the page number?
95. In Spanish, it is 891. And in Spanish, it begins line 10, I believe. In English, line 2 of 895. And we'll show this on the screen.
Disculpe, yo
I apologize, in Spanish. What page did you tell me?
Tab 5. Did I say tab 6? I'm sorry. Tab 5.
Ok. 5.
5.
¿No?
What page?
Spanish 891, line 10. We have those on the screen if it helps. Ms. Chapuis.
Sí, estoy aquí leyendo.
Sí, yes, I am reading.
You mentioned in February that you had a general view against royalties, and arbitrator Garibaldi is asking you here, what does it mean to have an opinion against royalties? against royalties for stabilized companies? Your answer: with the administrative and tax administration for the entire mining sector. That is to say, I think royalties are prejudicial for mining. And then I followed up and I said, okay, so just to be clear, your view generally about royalties is that mining companies in Peru should not be paying royalties. And your answer was, in Peru, in Chile, in the United States, all over the world. Do you see that?
Sí, en el ministerio.
Yes, at the ministry, we shared the opinion. The minister, Polo Tobar, we were all against the royalties, and Polo told me, we need to look into the way to make it the least prejudicial for the industry, and I told him, I think that we need to fight. And he told me, please understand me, the fight is lost already. We need to see how this can be not as harmful. And I said, I apologize, but I am no longer to participate. I said, I think that the ministry should fight for that.
That you say that you had those discussions with Vice Minister Polo, because if we look at the transcript, again, tab 5, in Spanish 890, line 6, in English 893, line 7.
¿Me podría decir de
Would you tell me, please, what document we are talking about?
5, C 1135.
ya y cuál
In
Where?
page 890, line 6.
o sea en el
That is, at tab 5,
Spanish, line 12, and in English, it's 893, line 7. You see that on the screen. So, what you said then was, and I quote from the English, I'm telling you that Vice Minister Polo and I did not discuss royalties. Contrary to what you just said now, you said then, I'm telling you that Vice Minister Polo and I did not discuss royalties, and then you continue, because in the first meeting we had about royalties, I opposed his position, and I said I'm not going to come again to those royalty meetings because I oppose royalties. And he said, if you don't want to come to these meetings, don't come. This is my opinion, my position. I don't agree with royalties. And he said, well, we'll continue to meet to discuss royalties. So I kept abreast, because people from my directorate went to these meetings on royalties with the Vice Minister, but I did not discuss this directly with him, and least of all, specifically on Cerro Verde. And then, if we can look at English page 895, line 18, and in Spanish it's 892, line 8.
en español cuál es el número que
892. You testify about that first meeting and you say, Engineer Polo said, I respect your point of view, but this battle is already lost. We have to carry on in the hope that Congress doesn't approve the royalties law that can be very prejudicial for the sector. So that's what you say Vice Minister Polo told you, correct?
le acabo de decir
I just told you the same. Mr. Polo was in accordance with me that the royalties were detrimental to mining, but the battle was already lost, and my position is, let us continue to fight. And he said, no more, we have already lost. Let's try to make it so that it is not very harmful, but we never talked about companies that were under the tax stability agreement, and the word Cerro Verde was never said. If you read all of the Chilean newspapers, they're talking about Peruvian royalties.
Chile.
Todas las contratos.
And they have removed all of the tax stability contracts.
Testimony. You confirmed that you said then what you said now. We'll have Vice Minister Polo come and explain his view. Let's continue reading. So I said, you say, don't invite me again to these royalties meetings. I'm not going to come. And he said, if you don't want to come, don't do so. Now, then if we look at page 893 of the English, from the beginning of the page, in Spanish it's 890, the question is, so you're saying now I'm waiting for this to appear on the screen. So you're saying now that you testified in writing in paragraph 53 of your witness statement that Vice Minister Polo's different view, you learned it from others. He never expressed to you directly this view. I'm waiting for us to show this on the screen. So the question is, so are you saying now that what you testified in writing in paragraph 53 of your witness statement about Vice Minister Polo's different view, you learned from others? He never expressed to you directly this view. And you said, I found out through other people and I had too much work quite simply, and I had decided not to go to these royalty meetings where there was a lot of discussion surely on royalties and other issues. But I didn't go to those meetings. From the first meeting onwards, I said I will not take part in these royalty discussions. And Engineer Polo said, well, I'm not going to make you come to those meetings. And then you say, just to clarify, he was your boss, wasn't he? And you say, yes. But the fact that he was my boss did not mean that I cannot have my own personal criteria on this. So your personal view on this did not seem to have been consistent with the view of your boss and the leadership of the ministry. Is that correct? This was your personal view.
Doctor, usted está confundiendo.
You are confusing the facts. I heard through others of a very personal opinion Engineer Polo had about Cerro Verde. He did not communicate it to me directly. A different issue had to do with the royalty project, the royalty bills in Congress, whereby everyone within the ministry knew that it was harmful to mining. In connection with those projects in Congress on royalties, I told Polo, let us fight. But he told me, the fight is over, we lost. Let us insist. And he told me, we have already lost. Let us have it not as detrimental as we can for mining. And I said, everyone has an opinion against royalty. So but please do not invite me here. I have a lot of work.
I ask a question? Buen día. Para entender.
Good morning. To better understand what you are saying, the meetings that you were not going to participate were the meetings on the discussion about the conceptual aspect of royalties, or how the royalties were going to be applied to the mining industries. Congress was looking into royalty bills. I think this was 2004. Then Mr. Polo started to convene us all, and at a meeting we all said that it is detrimental to mining. It's going to be harmful. And that was a big problem for me with the countries, some companies that we had privatized, because those companies that we had privatized were already paying a 3% royalty to the government. I apologize for the interruption. I do understand that. I'm asking you about the next stage, when we leave behind the conceptual discussion with Congress. Then there were meetings as to the application of the royalties, in particular for the stabilized and non-stabilized companies. Did the ministry have those meetings? Well, the ministry did not attend those meetings. It seems that they received all of the projects from Congress, and they were trying to see how to control. At the outset, there were some royalties for sales, then to operational profits. There were many bills before Congress, and it was only in June 2004 when the royalty law was passed by Congress. But immediately, the ministry did not issue the regulations. Without a regulation, it is impossible to implement a law. And that law was appealed before the Constitutional Court, that only issued a decision in late 2004. So I left the ministry in December 2004, when the Constitutional Tribunal, the Constitutional Court, had just issued a decision. But in November 2004, we were all at ease within the ministry. We were waiting for the Constitutional Court's decision. Thank you.
Come back to the distinction you made between royalties in general and the application of the royalties to Cerro Verde. And you said, and I'm looking at the transcript at 9:45:49, you said, I heard through others of a very personal opinion Engineer Polo had about Cerro Verde. So when you heard from others about this opinion of Vice Minister Polo that Cerro Verde should pay royalties on the concentrator plant, did you go to Vice Minister Polo to say you're wrong, or you're crazy, as you said yesterday, or did you do nothing?
I was in charge of approving everything related to tax stability contracts. I had a team, a legal team, and engineers who opined. And over the last 10 years, when Polo or I were not there, had acted pursuant to the same criterion with all of the contract signed.
Focus on my question. And my question was, when you heard through others that his view was that Cerro Verde should pay royalties on the concentrator plant, did you go and talk to him to tell him he was wrong? Yes or no?
Le,
I just explained the arbitrator.
le
And then
acabo,
explain.
le acabo de explicar.
I just explained the arbitrator that in 2004, that was my last year with the DGM, this law was passed in June 2004, and it was sent to the Constitutional Court. So we were not aware whether that law was going to be declared unconstitutional. So throughout 2004, there was a peaceful moment. We never talked about it. We were just waiting what the Constitutional Court was going to say.
To my question. My question was this, and I'll repeat it, and it's a simple question, a factual question. You testified that had yesterday, and in your witness statement, that had Minister Polo told you that Cerro Verde should pay royalties on the concentrator plant, you would have told him, "You're crazy, that is wrong." Now, you say he never told you. You learned about his view from third parties. And I'm asking you, when you learned about his view from third parties, did you go to him to say, "You're wrong"? And it requires really a yes or no answer. You either went to him and say, "I heard what you think and you're wrong," or you did not.
Mr. Alexandrov, you misrepresent the record. She did not say that when Mr. Polo said that Cerro Verde has to pay royalties, that you're crazy. The comment was being made with regard to the drafting of Article 83.3, which was in 1991, which was 13 years before.
Well, let's look at the transcript. The transcript says, oh, sorry. Do you have a recollection whether at that time Mr. Polo mentioned that the scope of stability would be limited to an investment project? Never. He never mentioned that. Had he mentioned it, I would have told him, "You're crazy."
That time is 1991. We were discussing the drafting of the mining law.
That's fine. And then Ms.
She did
Chapuis,
not mention Cerro Verde.
well, then Ms. Chapuis testifies that Vice Minister Polo, and I showed her the witness statements of Mr. Davenport and Mr. Reblanca, and Ms. Chapuis herself testified she heard from third parties later on that Minister Polo believes that Cerro Verde should pay royalties on the concentrator plant.
Well, that's a different question.
Well, that is my question. And I'm asking, may I continue? And I'm asking you, Ms. Chapuis, when you heard from third parties that Minister Polo believed Cerro Verde should pay royalties on the concentrator plant, did you go and tell him, "Cesar, you're wrong"? Yes or no?
When I heard that, it seemed strange because he was against charging royalties. So my first impression was just to listen and say, this person that comes with that piece of gossip may be wrong. And I did not attach any importance to it. And as I said it again in 2004, this was not an issue. We were not talking about that because it was in the hands of the Constitutional Court, and we were all waiting for the stability contracts to be respected. All of us had the same expectation, so it was not something that I was going to go and tell Polo, "What do you think?" or "What is it that you don't think?" It was not an issue. That law had been sent to the Constitutional Court. When the court in late 2004 resolved this, I was leaving the ministry.
So let me understand your testimony. First, you're saying you heard about his view, but you thought it was gossip. Second, you're saying I didn't go and talk to him because this was not a topic for discussion. But it was very much a topic for discussion between Cerro Verde and Minem in 2004, wasn't it? I mean, Mr. Davenport, Ms. Torreblanca have testified about numerous meetings at Minem discussing this exact topic, and you are telling us now that this was not a topic for discussion, correct?
With me, I don't know who Ms. Torreblanca and who Mr. Davenport may have met with, but in the General Directorate on Mining that I headed up, the position was always the same. The agreement signed by the Peruvian government is going to be carried out. The Peruvian government is going to respect the contracts that it signed.
Well, can we go to tab 34, RE 198, and that's an email you sent on June 11, 2004. To a number of people. The subject is a meeting with Cerro Verde new stabilization agreement. Let me ask you first who the addressees are. Who was Rosario Padilla?
Legal director. It's called technical legal director. She's the head of legal at DGM.
Jaime Chavez.
An attorney in the legal division. Today he's vice minister for mining.
Osvaldo Tovar is...
Es un ingeniero que
He's an engineer who is a witness in this proceeding.
And who is Luis Saldariaga?
Engineer in charge of reviewing the studies of the tax stability agreement.
abogado,
Attorney, General Directorate for Legal Affairs at the Ministry.
And so the subject, as we established, was meeting with Cerro Verde new stabilization agreement. And you're saying, can you come to my office on Tuesday the 15th at 11? Matter request for inclusion of the sulfides project in the stabilization agreement of Cerro Verde. Is that legal? So you just said, and you've stated that in your witness statements, that from the very beginning you and everybody believed that the 1998 stabilization agreement stabilized the whole, what you call the mining unit. But on June 11, you still have a question whether the inclusion of the sulfides project in the stabilization agreement is legal. Isn't that right?
It's not as you are describing it. As I explained in the February hearing, we had had lengthy discussions, including with Minister Polo, because 10 years had gone by and the companies were once again making large-scale investments. The companies had their tax stability agreements, and the company Tintaya asked for what we called a succession of the tax stability agreement because it was going to make $120 million investment. All of the discussions that we had, the lengthy ones, because of Tintaya, we had reached a consensus that Tintaya's application wasn't in order. the idea was to terminate the stability agreement they had and sign a new agreement to cover the investment they were going to make, and that they be given an additional 15 years. And after many meetings, we reached the consensus that that was illegal, that the law did not provide for it. It did not provide for any succession of tax stability agreements. So, once again, I found out that Cerro Verde was seeking a meeting because of the $800 million concentrator. And so in my mind, my first reaction on Friday, 6:15 in the afternoon, when I'm scheduling meetings for the following week, I thought that Cerro Verde was also going to come with the same request as Tintaya, to terminate the contract or agreement they had and to ask for a new one to cover the next 15 years. That's why I asked, is this legal? Because we had already done this with Tintaya. Now, Tintaya was a case of secondary mining. It wasn't the same as Cerro Verde. So, the day of the meeting, Ms. Padilla came in and she told me by way of greeting, you were mistaken. Cerro Verde doesn't want a new tax stability agreement.
Ms. Chapuis, the differences, your discussion of the differences between Tintaya and Cerro Verde are very interesting, and we'll come back to that. But with all due respect, what you are asking here is not about Cerro Verde's willingness, as you understood it, to terminate the existing contract and sign a new one. Let's look at the email. You say request for inclusion of the sulfides project in the stabilization agreement of Cerro Verde. You are not asking whether it's legal to terminate the contract, the existing stabilization agreement, and enter into a new one. You are asking, is it legal to include in the existing stabilization agreement the sulfide project? Isn't that right? There is nothing here in your email about terminating the existing contract and signing a new one.
Under the subject line, I clearly wrote new tax stability agreement. This was 2004, and Cerro Verde had a contract for, or an agreement for 5 years. It had 10 more years, and they were making an $800 million investment. So naturally, one presumes that they're going to want 15 years and not the 10 years that were remaining. That's why I made the mistake, and I said new. They're going to come in and ask for a new agreement. And Ms. Padilla, who was more familiar with the details, said, no, you're mistaken. They don't want a new agreement, as Tintaya did. They're going to stick with the same agreement they'd already signed for the next 10 years? Yes, for the next 10 years, nothing more, not one more day.
So you've testified, and witnesses from Cerro Verde, Ms. Torreblanca, Mr. Davenport, have testified that they met with you in 2003, in 2004, so to discuss whether the existing 1998 stabilization agreement covered the concentrator plant. And you're saying that until June 11 of 2004, you were under the erroneous impression that what they were asking was a new stabilization agreement. Is that your testimony?
In 2003, I met with them because they came to ask me whether the tax break that they had, which was a reinvestment of a profit and respective payment of income tax. This is in the record. We made a decision in December of 2003. We told them that even though that provision had been repealed 3 years earlier, we were going to respect what was set in the tax stability agreement. That was in 2003. Copper was at 85 cents. They came back in 2004 when copper had gone up to $1.20. And so there they were more positive, and they thought that they could build that concentrator with by investing the profits that they had obtained in the 4 previous years or the 4 coming years or something like that.
So let's leave the reinvestment program aside for a moment. I understand you had meetings about that. Is it your testimony that until June 11, June 15 of 2004, you did not know that Cerro Verde was asking for a confirmation that the existing 1998 stabilization agreement covered the concentrator plant? You did not know that until Ms. Padilla told you you've made a mistake. Is that your testimony?
Mr. Alexandrov, we were talking about an $800 million investment, okay? $800 million.
Answer my question. I know what we're talking about, $800 million. I'm asking you a specific question. You said when you sent this email on June 11, you thought they wanted to terminate the existing agreement and enter into a new agreement that would cover the concentrator plant. You've also testified that you had meetings with them. So my question is it your testimony that until June 11, 2004, you did not know that their position was the concentrator plant was covered by the existing agreement and they wanted a confirmation of that? You did not know that and you thought they wanted a new agreement. Is that your testimony? I'm asking you to confirm, yes or no.
I had not met with them, and I did not know exactly what they were going to ask for. But Ms. Padilla already knew, and she told me they're not going to ask for a new agreement, as Tintaya did. They want to make sure that it's in the contract, the agreement that they already had, which had only 10 more years remaining.
Thank you very much. That concludes my cross-examination.
Any redirect, or do you want to? Yeah, please.
La impresión que da
The impression that Cerro Verde gives is that they wanted to ask for a written confirmation, and you had told them or insinuated to them that there was no need because it was covered by the 98 agreement. Is that right? Did you give them enough reason to think that they might think? That is to say, you assumed the personal responsibility that it not need to be presented in writing despite your willingness to do so? Yes, that is true. As I have said here, I worked for 3 years with the inspectors from the Ministry of Energy and Mines when I was at Tintaya. I was on the other side of the table. I was the mining company. And I knew what the criteria was of the SUNAT and of the ministry when it came to dealing with the investments that were made during the period covered by tax stability agreement. When I worked at Tintaya, when I was on this side of the table, I knew that all of the investments made, whatever the amount, were included. There was no qualification process in the ministry to determine whether this investment qualifies, but this one doesn't. This one, yes, this one, no. There wasn't. you were given a time period and all the investments were covered. And I've also noted here that mining is very capital intensive, and on a constant basis, on a monthly basis, major investments are made. So I clearly understood what a tax stability agreement was about and and how both the ministry and Sunat viewed them. Nonetheless, you were telling us that there was gossip that there was a contradiction with your boss. Excuse me, please. That there was a contradiction with Mr. Polo. Indeed, you say that you trusted that the Constitutional Court would resolve the issue. Wasn't there more than enough reason to say, apply for it in writing and get the clarity of yes or no, rather than telling them no need to submit that? Excuse me, but you're mixing up two different things. You're mixing up investments in a context of tax stability, which was the concentrator. Does the concentrator fall within it or not? And then there is the royalties law, and in all parts of the world, tax stability agreements are respected. And this was a matter that the Constitutional Court was just resolving, and it resolved it in an unheard of or unprecedented manner. In 2004, we were not discussing royalties and how they were going to be handled, because the matter had been forwarded to the Constitutional Court. And that's why I wanted to cite the example of now, right now, this month in Chile, that for the discussion of royalties, they've separated all the companies that have tax stability agreements, and they're looking at them in another way, and they're going to respect them up until 2024, 2025, 2027. The states respect tax stability agreements, and they don't invent taxes or give them different names for them to not be included in a tax stability agreement. Thank you very much.
I would like to ask a follow-up question, Anna, if you don't mind. We already discussed yesterday your views on the scope of the stability agreement, and yesterday you testified that it extends to the entire concession, regardless of its Exhibit 2, the investment plan, and that forms an integral part. Let me now turn to Exhibit 1 of the stability agreement, and maybe you can put it on screen that it's easier for the witness to discuss it.
Lo que quería aclarar.
What I'd like to clarify is that investment plan is very summary, and even though it's very summary, that it includes the stripping, the stripping away of all the primary sulfides.
So let's now move to Exhibit 1, to the 1998 Stability Agreement. And there, reference is made to the concession of beneficiation, and the beneficiation plant was a capacity of 33,000 metric tons per day. Mm-hmm. Is, in your view, this description of the capacity of 33,000 metric tons per day important and in a way defines the scope of the stability agreement? Or is it also irrelevant, in your view, for the scope of the stability agreement?
No, what it's saying there is that there is a beneficiation concession which only has, because that's all there was, a beneficiation plant with a capacity of 33,000 tons. at that time. That concession beneficiation, which I was describing here, was there was just one plant for 33,000 tons operating, and the small concentrator for 3,000 tons was at a standstill. And this project, as the oxides were removed as part of the strip mining so as to be able to reach the primary sulfides, were sent to a new plant which no longer had a capacity of 33,000 tons, but rather 48,000 tons. And so they would remove this oxide material and send it to that plant, which cost them $50 million. Because the other, well, the difference is the crushing equipment and the trucks. So they send it to that new plant. Now, as I explained yesterday, these tax stability agreements set a time frame. These tax stability agreements set a time frame in which you, the mining companies, can make all the investments you deem advisable. And you can extract natural resources.
Entonces, usted no.
And so you can't set or take note only of the size of this plant. So what it says there is that the beneficiation concession currently, at the time it was signed, only had a capacity of 33,000, which then became 48,000. And there, the mining concessions, Cerro Verde 1, 2, and 3, as I commented yesterday, they were, say, this big, and they covered 7,000 hectares.
When the concentrator was built, what was then the capacity?
The concentrator had the beneficiation concession had an area of 451 hectares, and this area had to be expanded because the concentrator is very large. And it was expanded to over 1,000 hectares, twice the size. Now, what is this geographic area for? Well, it's simply for the geographic information systems at the ministry. Now, your question about the capacity has an environmental connotation as well, and you are right. The capacity increases, and it is required to respect environmental provisions, environmental laws.
Capacity increase, how much?
The capacity increased from 48,000 tons per day. Well, the problem is that a plant
Increase?
3 or 4 times more, let's say. But look, the thing is, we cannot measure, well, as we talk about how much is 48,000 per day, and it went to about 4 times as much, but it's a different type of process. But, well, now, here we're talking about the administrative issue, let's say, but that doesn't mean that Cerro Verde hasn't also delivered or submitted an environmental impact study. With its new concentrator plant, it was required to conduct a new environmental impact study.
My focus is not on the impact study. My focus is now on this increase by 3 to 4 times the capacity. And so the original beneficiation concession at the time the stability agreement was concluded, 1998, covered 33,000 metric tons per day. Now we talk about a capacity of 3 to 4 times more. Why did you think that nevertheless the beneficiation concession valid at 1998 did not in a way limit or define the scope of the stability agreement, but the new concession, which was rendered 8 years later? Why do we need to consider, in your view, a concession which was only granted many, many years after the stability agreement was concluded? Can you explain what your view on that is?
Because the mining companies are continuously making investments to grow, because the content, we're talking about volumes, because the copper content is reduced over time. I don't know if you know what I mean. That is to say, when it was oxide ore, then you have an ore coming in with a content of 0.7% copper. But when it becomes primary sulfides, the content it drops to 0.4. This requires you to have a larger plant because you need to increase the volume of ore that you remove in order to maintain the production of physical copper that needs to be the yield of that process. Now, it was in Peru's interest for the mining companies to expand their capacity, their output, for more physical copper to be produced. That is why these tax stability agreements are entered into, so that the company is able to make all the investments and so that it can increase its capacity. That's why it was granted the reinvestment of profit, because if that benefit were not granted, it wouldn't have been possible to build the concentrator, which is the largest plant. It's larger because it processes ore with 0.3 or 0.4% copper, whereas the oxide plant processes ore that is 0.7 or 0.8% copper.
So just and I had to verify my understanding. So your testimony is that the stability agreement covers whatever capacity is ultimately produced, regardless of what has been stated in Exhibit 1.
Sí.
Yes.
Yes.
And did you verify this understanding of yours when Cerro Verde came and wanted to build the concentrator, thereby enlarging significantly 3 to 4 times the capacity? Did you verify with your legal team that this extended beneficiation concession would be then the decisive one under the stability agreement?
Yes, perhaps you may be confused about what a beneficiation concession refers to, and excuse me for telling you a bit of history. When we were a Spanish colony, King Carlos V imposed this beneficiation, instituted beneficiation concessions and imposed a rate.
I will be happy, Anna, to listen, and we get to
Yeah,
that, because I have questions on another extension of the beneficiation concession too. I just would like you to answer my question.
Esa es una...
That's a rate that dates to the times of the King of Spain, where at the time of production.
To talk about the King of Spain now.
Yeah.
I would really just
Yeah.
get a simple
Sí.
answer on my question
Sí.
of whether you have discussed the extension of the beneficiation concession by 3 to 4 times with your legal team. Whether it would
Exacto.
bring it under the scope of the stability agreement. This is my question, and I would like your answer on that.
Estaba...
The beneficiation concession that Cerro Verde had, it was called the Cerro Verde beneficiation plant, was fully covered. There were no restrictions for extending the capacity or the geographical area. No provision imposed any restriction. To the very contrary. There was expansion, and they had our full support to extend the capacity or the surface area.
Then let us pull again on screen this exhibit RE198 that Mr. Alexandrov already had referred to. Request for inclusion of the sulfates project in SA of Cerro Verde. So is this legal? What was discussed then in this meeting with your team on June the 15th? Did it challenge or discuss your views that the extension of the beneficiation agreement would bring the concentrator under the stability agreement, or what did you discuss? On what did you seek legal advice? I really just want to understand.
The subject says meeting with Cerro Verde, new stability agreement. I made a mistake. I thought that Cerro Verde was going to ask for a new stabilization agreement. They were going to do away with the one that they had because 5 years had elapsed, and that they were going to, they only had 10 years left, right? So they were going to ask, I thought, the 15 years that they could ask. 10 years they still had remaining. But with a new contract, they would have gotten 15 years.
I understand. And when your misunderstanding was corrected and by one of the email recipients, what happened then? And did you nevertheless discuss with them the request for inclusion of the concentrator project in the stability agreement, or did you not discuss? Did you cancel the meeting? What happened?
We met as we usually met, and we took a starting point, which was that they were not asking for a new agreement. They're not asking for a new agreement. That would mean that the older contract would be terminated, but they're not asking for a new one. The only thing that they're asking for is for this to be taken as an investment within the agreement that they already had.
And what was then the comment by your team members, by the lawyers? Did they confirm your view that the extension of the beneficiation concession would bring the concentrator under the scope of the 1998 stability agreement? Did the lawyers confirm that to you?
Yes, because it was fully protected. All investments were fully protected. We didn't have a single provision that said that for new investments, you needed to qualify for them. All of the investments made within that 15-year period were included. They only had 10 years remaining, Cerro Verde did.
Que se hiciera en esa.
All investments made in that mining unit.
Just again, because I just want to be precise on this point. So it was confirmed and discussed in this meeting that the extension of the beneficiation concession would bring the concentrator under the protection of the stability agreement?
Sí.
Yes, totally.
Who exactly confirmed that to you? Was it Padilla Rosario or who of the individuals?
No, esta reunión
No, as you can see, this meeting includes lawyers and engineers. Us engineers explained to the lawyers the technical issues, what was going to be done. It was a concentrator, what was going to be processed, all the technical matters. So the lawyers had all the details, of course, in connection with the laws and regulations, and they would say whether things proceeded or not. And they're saying, okay, this can go ahead. There's an investment within a stabilized mining unit. There is a stabilized mining unit. There are mining concessions and beneficiation concessions.
And do we have any minutes of this meeting in which you obtained this express confirmation by the lawyers? Any other record? No, it was just this meeting. So you rely on this meeting on the 15th of June. This effort to give this assurance to Cerro Verde, you are safe.
sí, esta era
This was not the only company that had put a request like this to us. There were other mining companies that received a benefit that was the same or similar to Cerro Verde's.
And yeah, so and Mr. Tova also attended the meeting, right?
exact
That's right. And he never made any observation whatsoever. He knew what we were deciding within the DGM from June 04
Thank you.
onwards.
This, yes.
Usted sabe que ha habido
You know, there are a number of contracts, a number of stabilization contracts have existed for Cerro Verde. The third one was made in 2012. In the 2012 contract, what you are saying was implicit is included expressly in the stabilization agreement. This new 2012 agreement, doesn't it entail a rectification that a mistake was made and that is why things were rectified in 2012?
que primeramente en 2012 yo no estuve.
por supuesto.
Ya.
Cambia el canal.
Segundo,
First, I wasn't there in 2012. Second, the provisions of 91 and 92, the ones that we drafted with Mr. Polo, well, they were based on an investment promotion law that was declared of national interest. The country was in ruins, and there was an internal war with a high level of terrorism. Perhaps you may think that these laws are very benevolent, but we have to look at the context of 1991 and 1992. Oftentimes, we didn't have electricity in our office because the terrorists had blown up the electricity grid in Lima. That is the context in which this law was passed. Now, if things were changed in 2012, well, the context was different. Thank you very much.
So please, Clement, go ahead with your and I redirect, and then we will probably continue with our questions.
Please, if you want, you can go ahead with the questions. We would need about a couple of minutes just to confirm that I have the views of my team before I ask questions.
Okay, I think we are well in time. Maybe I continue with my questions, and then you can consult. I have studied overnight and everything again relating to this extension of the beneficiation concession. And I note that there was this application in August 2004 by Cerro Verde, which is Exhibit CE 457. And I also noted that there is no mentioning of the stability agreement. But as we discussed, the extension of the beneficiation agreement has, in your view, a very, very great effect. So I also looked at the approval of the extension of the beneficiation extension, and this is Exhibit CE 476. And so maybe we can look together to this document that you can explain better to me why, in your view, it has this really enormous effect. So if I look to the signature lines, it appears that it was Hugo Mendieta Espinosa, an engineer, who suggested that the director authorizes the construction and installation of the modification of the beneficiation concession, and that it was then countersigned by Osvaldo Tovar Jumper. Is this correct? It was not you, it was Mr. Tovar who signed this document.
That was the procedure that had to be signed by Mr. Tovar. But what is your question specifically? It says here that the installation and construction of a beneficiation concession for Cerro Verde is to be authorized. So, but specifically, ma'am, what is your question?
Solo firma.
This is signed by Mr. Tovar, indeed, yes.
Exactly, and this is what I noted. And I thought, if you give the assurance to a company that the extension of the beneficiation concession will give them the protection that they seek, I thought you may have been involved also in the extension of the beneficiation concession. But my understanding is, and this is what I just want to verify, that it was Mr. Tovar who gave the final approval or authorization. Or were you involved?
Mr. Tovar, who's an engineer, was the person in charge of approving the extensions. To conduct the approval on the file, he asked for the cash flows that showed exactly the tax regime. He also participated in all these meetings at all times where we said that the concentrator was within the tax benefit granted to Cerro Verde. He never put any objection to me.
I read on the bottom of page 2 that based on the evaluation, Cerro Verde has complied with the ordinary procedure for concession of benefits stipulated in Articles 35 and 36 of Executive Decree number 1892 FM. What does this executive decree state?
¿Cuál es?
It indicates the procedure to apply for a beneficiation concession, an extension of that concession, and it's a change in the procedural rules.
And does this executive decree also discuss or address stabilization agreements?
These stabilization agreements have a specific set of regulations that govern them. I remember the name. It is the regulation of articles XXXX. This is a regulation that has to do with the general mining law that includes the full range of procedures that we had to go by.
But if I understand you correctly, you are the expert on this law, and these articles or this executive decree does not concern stability agreements. It's about all other aspects.
That's exactly right. But when you do this procedure, you need to establish the cash flows. And if you look at the file submitted by Cerro Verde, you can see that Cerro Verde was already considering tax stabilization.
And this is because they also submitted the feasibility study, which was based on the assumption that it was stabilized. Is this correct?
That's exactly right. Also, Mr. Tovar asked them to provide a lot of information. He met many times with them, many times.
Thank you. This would conclude my questions. Do you have additional questions? No? Then please.
If you could just have 2 minutes. Thank you. Mr. Puis, I have a couple of questions for you. The President asked you about whether the lawyers in your team in the DGM shared the view with you. Let me ask you that question. In the internal meetings that you had discussing Cerro Verde's question regarding the concentrator inclusion in the stability agreements, do you recall whether all lawyers in your team, Ms. Padilla and the others, were agreed that the inclusion of the concentrator in an expanded beneficiation concession would mean that the concentrator is stabilized?
Sí, estuvieron totalmente de acuerdo, no hubo ninguna objeción.
Perdón. No llegué a escuchar la respuesta porque no terminaron de interpretar la pregunta todavía.
Okay.
Can you repeat the answer one more time?
Sí,
Yes, all of them were in full agreement, and none of them made any objections.
You have discussed that issue with them.
sí,
Yes.
además,
Also, they coordinate things constantly with the mining concession and the legal advisor of the ministry, and nobody placed an objection.
Also pointed you to Annex 1 of the Stability Agreement, where the beneficiation concession is described, and a specific capacity of the beneficiation concession. In the practice of the DGM at the time that you were there, was it the view that the capacity, as stated in the stabilization agreement, limited the scope of stability guarantees?
no.
No, not at all. We did not qualify the investments in any way whatsoever. The investments that could be covered during this 15-year period. There was no qualification whatsoever. All investments were welcome.
Of the DGM, have you seen companies increase the expand their beneficiation concession to include new investments?
Sí,
Yes, we have seen that.
Does this include also companies that have been stabilized? Companies
sí,
that have
todas las empresas
Yes, all of the companies were under a stabilization agreement. We had over 40 stabilization agreements.
Okay. What I was asking is whether you have observed in your practice at the DGM that companies that had stabilization agreements that included a beneficiation concession have expanded that beneficiation concession while the stability agreement was enforced to include new investments.
Is that
Sí.
part of the...
Yes,
I'm just asking a question.
Well, I'm asking, you're doing redirect. I don't think I cross-examined her on that.
This is in response to a question that the President asked.
I'm not sure. I'll leave it in the hands of the President. I don't think the President asked about other companies.
The President asked a specific question about Annex 1, whether the 33,000 metric tons per day in the beneficiation concession limited the scope of the beneficiation concession. And I'm following up on that specific question.
Please go ahead.
So my question was whether while you were at the DGM, in your experience, can you describe to us whether companies that had stability agreements that included a beneficiation concession expanded that beneficiation concession to include new investments?
sí,
yes, many of them, almost all of them, they were always making investments to expand capacity.
And at the time that you were at the DGM, was it the DGM's view that those new investments in expanded beneficiation concessions that were stabilized were also covered by the stability agreement?
Sí, está.
Yes, they were covered. All of the investments that were made within the 15-year period, not a day more. All of the investments, all kinds of investments, there was no restriction.
And when the beneficiation concessions for those companies were expanded to include the new investments, did the beneficiation concession approvals mention stability agreements?
Indirectly. They have to attach the cash flows, and that shows in the economic and tax structure. Indirectly, yes.
I think any more questions? No further questions. Thank you very much.
One question really follows up on one of your questions, Madam President, and the question was about the meeting on June 15 that was discussed in the email that Ms. Chapuis sent on June 11, and the presence of Mr. Tovar. And so I want to show Ms. Chapuis the second witness statement of Mr. Tovar, paragraphs 16 and 17, and we'll put them on the screen. But I would like to read the English into the record. So it's paragraph 16 first. And so Mr. Tovar says, what I do remember is that on June 11, 2004, Ms. Chapuis informed DGM officials, including MINEM's attorneys and legal advisors, that Cerro Verde was applying to include the concentrator project under the stabilization agreement. Specifically, Ms. Chapuis sent us an email with the subject line meeting with Cerro Verde new CET, whereby she called us to a meeting on Tuesday, June 15 in her office, informing us about a, quote, request for inclusion of the sulfides project in the stabilization agreement, close quote, and asked us whether Cerro Verde's application to include the concentrator project under the agreement was legal. It is clear from this email that Ms. Chapuis, one, knew that the primary sulfides project was not included in the tax stabilization agreement, Contrato de Estabilidad Tributaria, and that she was passing along the company's intent request to include it, and two, she did not know if Cerro Verde's request was legal or not, so she had to consult with her team, including me. He then reproduces the email, and he continues in paragraph 17. Given that I was the individual responsible for examining and approving the expansion of the area and installed capacity of the beneficiation concession, it would make little sense for Ms. Chapuis to have confirmed to Cerro Verde that with the expansion of the beneficiation concession area, the effects of the stabilization agreement would be extended without first discussing with me. I can confirm that this discussion never took place, and I never stated, nor could have stated, that this expansion could have included the concentrator under the scope of the stabilization agreement. Having seen that testimony, Ms. Chapuis, my question is, do you believe that Mr. Tovar misremembers what happened at the meeting and his testimony is incorrect?
As I have explained here, we were having all of these conversations regarding Tintaya. Tintaya wanted a new tax stability contract to terminate the one they had because they were making an investment for $140 million. They wanted to initiate, to sign a new contract and to have 15 additional years. So I was misinformed, and I thought that Cerro Verde, with their investment, wanted to do the same because they had 10 years of stability, so it was going to take 4 years to build, so they would only have 6 years left with stability. So I reasonably thought that they were going to ask for a new CET, but Dr. Padilla told me no, they are not going to request a new tax stability contract. They will remain the same one.
Was different. Is Mr. Tovar misremembering what happened on June 15, and is his testimony incorrect? That was my question.
No voy a opinar.
I am not going to opine on other witnesses.
Thank you very much, Ms. Chapuis. This concludes your testimony, so you are now released as a witness. Thank you.
Mil disculpas.
I apologize. Oftentimes it may have been, or I could have had better manners or been kinder in my answers. I thank you.
You? Thank you. So our next witness would be claimant's witness, Mr. Estrada, right? Okay, sorry. Then we do a break now of 15 minutes, and then we continue with Mr. Estrada. Welcome, Mr. Estrada. You have been called as a witness in this arbitration by claimant. I may briefly introduce the tribunal. I'm here with my co-arbitrators, Professor Tawil and Dr. Cremades. My name is Inka Hanefeld. Under Rule 35, paragraph 2 of the exit arbitration rules, you are required to give a declaration. Can you please read it out? It should be on your desk.
Good morning. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. Then we turn to your witness statements. Do you have your witness statements CWS 6 and 17 in front of you?
Sí.
Can you
Yes.
confirm that these are your witness statements and that they correspond to your recollection?
Sí, son mis declaraciones.
Yes, these are my statements.
We turn to claimant for the direct.
Thank you, Madam President. With your permission, I'm going to switch to Spanish.
Thank you for being here, Mr. Estrada. Thank you. I will be asking you some brief questions regarding your statement. Did you read the statements presented by the president of the tax tribunal of the tax court in this arbitration, Ms. Olano? Yes. You might have seen that Ms. Olano said that she appointed her personal assistant, Ms. Ursula Villanueva, as alternate for Chamber 1. What do you opine about this? What is your opinion? First, during my 14 years at the tax court, I never heard of alternate advisor. There is not a position that we see in the manuals or in any rule of the court. The first time that I heard of that term was for this arbitration. Those who worked at the tax court, we had advisors, chamber advisors, and that is quite different from the position that this alternate had, that was the advisor to the president's office, Ursula Villanueva. The advisors usually had to be accepted through a merit competition, and this was different from the advisor to the president, who was trusted staff. That is to say, she was appointed by her without any other private competition. And we also reported our work to the vocales, and regardless of the chamber, she did not do so. Her only boss was Dr. Oldano, who was her right hand. And the work by the chamber advisors was to participate in the drafting of bills for our vocales, but Ursula Villanueva, as advisor to the president, only had to help with the task that Dr. Olano had, and none of those tasks was related at all with the issuance of resolutions. That is something that was the purview of the chamber. An additional difference is that chamber advisors, whenever they became members of the tax court, had a specific term. In the case of Ursula, this was not so, as trusted staff she could be removed at the will of Dr. Oldano. Also, Dr. Oldano does not state the truth when she said that she appointed Ursula Villanueva to work with the first chamber. I've been there for 14 years, and I never saw Ursula Villanueva go to a chamber as an advisor. What happened, in fact, was that the files were actually removed from the chamber and taken to the office of Ursula Villanueva that was in front of Dr. Oldano's office, and that's where she worked on the files. But she never participated as an advisor that was in person at one of the chambers. This was very unusual because even though the tax tribunal reports to the Ministry of Economy and Finance, the various chambers, when dealing with case law or resolving disputes as the last administrative resort, had to be done within the room. And the fact that the advisor to the president was removing the files was also breaching this principle of independence that should have been characteristic of the tribunal. The vocales did not have any contact with the outside world or the Ministry of Economy. The only contact that the institution had with the Ministry of the Economy was through Dr. Olano, the president of the tribunal. But the rooms had no contact. And by having her own advisor deal with the files, that was a completely regular situation. Dr. Olano justified this decision with two arguments. She said that she did so because there was no rule against it, and that is completely wrong. In Peru, all public servants, such as Dr. Olano, have to observe the principle of legality. The principle of legality assumes that a public servant may only do whatever is provided for under a rule or the law. There is no rule against it, but they needed to have a rule to empower her to do so, and there was no empowerment in the laws. Dr. Oldano also said that she did it because there was shortage of staff. In the 14 years that I was at the tax tribunal, we always had shortage of staff. We always needed advisors, and given the shortage of staff, Dr. Olano, in full use of her powers, had to call for this public competition to have new advisors come into the institution. But if because of an urgency or a situation or to resolve a file or a record, they could not wait for this public competition based on merits, what should have been done, as they did, was to move around advisors from one chamber to the other one. Dr. Aldano presented two examples of that here, and they are proper examples, former colleagues of mine. I don't recall the name exactly, and Juan Regalado was one of them, and she moved staff from one room to the other, and I also was seconded to another room or chamber to help with some specific records. So what Ms. Oldano said is completely irregular. It is irregular for her to appoint her only advisor to work on a file, but it is even more irregular for Dr. Olano to participate in the discussion, deliberations around this record. So I think that what she says is incorrect.
Thank you very much, Mr. Estrada. In the last round, Peru presented the clarification by Mr. Sarmiento, who was a vocal number 10. Now Mr. Sarmiento, says that the 2006-2007 royalties draft was considered by that chamber. I believe that Mr. Sarmiento's position is completely biased. Mr. Sarmiento from Chamber 10, which met in relation to this matter, there were 3 members. The other 2, Morano Valdivia and Luis Cayo, are no longer members of the tax tribunal. They are engaged in private practice, and the only current member is Mr. Sarmiento. Now, as a current member, it is evident that he could not say something other than what he's saying. He could not say that, in effect, there wasn't a proper deliberation of the matter before or in Chamber 10, because that would imply that he would be committing an omission in his duties, and that has repercussions. An administrative proceeding against Mr. Sarmiento could be initiated on this ground. Let us also recall that Mr. Sarmiento's direct boss is Ms. Olano. So it's clear that his statement helps to bolster that of his direct superior, but she's not only his superior, but also Ms. Olano has a lot of weight in the process of ratification to which the members of the tax tribunal are subject every 3 years. So to say something different than Mr. Sarmiento said could put at risk, well, he would be opposing his superior, and it would place at risk his ratification process. Now, Mr. Sarmiento holds or upholds as evidence in one way or another that there was deliberation on that matter with only 2 documents. He presented session minutes, and he also presented as evidence the decision signed by the 3 members. Now, in the minutes, if you have occasion to review that document, it's a document that it doesn't prove whatsoever that there's been a deliberation. It is a document that is drawn up by the administrative clerk of the chamber, and it contains only the result of the vote in a matter. In the minutes, they have the taxpayers' information, the number of the matter, the number of the decision, the outcome of the vote, but it doesn't show that there's been any deliberation. And the second document, which is the decision signed by the 3 members, doesn't show either that there's been deliberation, because if you take a look at that decision, it is identical to the decision that was issued by Chamber 1 3 weeks earlier. It's impossible to think that 3 members in a different chamber, in a different room, or rather in a different chamber on a different date, deliberate and have the exact same conclusion as another chamber. This arbitral procedure is unfolding into before different tribunals. It would be the same logic to think that 3 arbitrators, despite the fact that they conclude the same thing and have the same considerations for their decision as the other 3 arbitrators who already looked at this case in February. So it is not justified that the fact that it has been signed by all 3 members doesn't justify or prove that there's been deliberation. Thank you very much. With that, we conclude the direct and yield to the attorneys for Peru.
We'll turn to Spanish with your permission. Buenos días, señor Estrada.
Good morning, Mr. Estrada. It's nice to see you once again. We already know one another, but just so that it's in the record, I am Maria Carolina Duran, and I am a member of the team representing the Republic of Peru in this arbitration. Well, as last time, we need to speak with pauses. This rule applies to you and to me. It's also very important that we take a pause between my questions and your answers, and I do likewise when you conclude your answers. Please don't take my pause as an invitation to continue speaking. I'm just waiting for the interpretation into English to catch up with us. And since we have little time, I would ask that you please answer my questions directly. Mr. Estrada, have you seen the transcript of the last hearing? Yes, I was able to see that. Of your witness statement? Likewise. Excuse me. Did you see the transcript of your testimony at that hearing? Yes, only that. And what about the opening arguments? No. And the testimony by President Olano and Mr. Sarmiento, did you see those? No, not at all. You're an attorney licensed since 2006, correct? Yes, since 2006. And you began to work at the tax tribunal in 2004, is that right? That is right. So you began to work at the tax tribunal before you ended your undergraduate degree in law, correct? Yes. And you worked, as you said a moment ago, at the tax tribunal for 14 years, correct? Yes, that is correct. And just to continue, you left the tax tribunal in 2018, correct? Yes. During those 14 years, you held the position of asesora, law clerk, at the different levels, correct? Yes, at all possible levels. But always as a law clerk, correct? Yes, of course. Now, in those 14 years, you were never law clerk for Chamber 1, correct? Yes, I was, actually, a couple of times. Not as the permanent law clerk, but I left the chamber on customs, and I went through all the different chambers at some point in time. At the last hearing, when I speak of the last hearing, I'm talking about the hearing in the case of SMM Cerro Verde. You said that you were in chambers 2, 4, and 10. Are you changing your testimony? No, I also said that I had been in the other chambers for some time, or such as for specific cases such as this case in Chamber 1. And in those cases, when you were in Chamber 1, was it because you were designated there temporarily just for a particular case? Yes, for a specific time period or for a specific case. And in Chamber 1, when you were at Chamber 1, you were not involved in the Cerro Verde cases, is that right? No. And when you're in Chamber 10, you were not in the Cerro Verde cases either, is that correct? It is correct. Then, in your witness statement, you established that since 2019, you've worked at a law firm called TS Asesores, correct? Yes. Do you continue working there? Yes. In which year was that law firm established? I think it was 2017. And I was looking for information about this law firm, as I did the last time, and I did not find a website. Could you tell us, please, how many lawyers work at that law firm? The firm has 3 partners, 4 senior attorneys, and several legal assistants, depending on the workload, actually. I believe that about 12 to 20 people work there. Who are the partners? Jorge Mendoza, Ivan Vera, and myself. Now, just for clarification, why at the last hearing did you tell me that, formally speaking, you were not a partner at that law firm? In the Articles of Incorporation, I'm not a partner, but I also noted that I am treated as a partner. I charge as a partner. I purchased the office where the law firm works out of as a partner. It's only in the Articles of Incorporation that I wasn't there because I was working at that time in the public sector. And at the website, at the LITIN website, it appears that you also work at a law firm called Mendoza, Vera, and Estrada. I understand this is the same as TS Asesores. Yes, the same partners. At the February hearing, you established that that law firm was not working, was not operating. Is that still the case? Yes, it is.
Por eso ese estudio tampoco tiene una...
And that's why that law firm doesn't have a website either. Yes, that's right. It exists, and we don't intend to have a website. Now, at the Cerro Verde hearing, you said that Cerro Verde is a client of TS Asesores law firm in relation to the SMM Cerro Verde case, correct? Yes. And you also said that when you said Cerro Verde's lawyers, you're talking about the international lawyers of Cerro Verde, that is, say, the Debevoise firm, correct? Correct. Is it correct to assume that the Debevoise lawyers are also clients of TS Asesores for the purposes of this arbitration? Freeport? No, the only client is Cerro Verde. So that was just for the previous case? Cerro Verde, I understand, I'm not all that familiar with arbitration, is the client of the law firm. There are 2 shareholders. Cerro Verde has 2 shareholders, but the client is SMCV. Okay, but now I'm a bit confused because you told me that the client was the Debevoise law firm. In both cases,
Him to the exact place where he said that his transcript.
Sí, por
I
supuesto.
think that's not what he said. So I think we would be grateful if you could show him exactly what he said.
Sí, podemos ir a
yes, we can turn to the transcript, which is at tab 3. At page 1047, in the Spanish language version, I don't have the page number for the English language version. This is it's 1043 of the English. Do you see it? Yes. So the first question that I put to you is, SMCV, which I will refer to as Cerro Verde, is or has been a client of TS Asesores? And your answer is, it is the client of TS Asesores. And then if we scroll down to line 22 of the same page, it says,
I think it's important for context. Yeah, I was just saying, if you could read the following line immediately after the one that you read, because I think it's important for context.
I'm sorry. His questions, he can do it on redirect. I don't think they give any context. I will read it just for the record. Y la pregunta es,
and the question is, does TS Asesores have any relationship with the Rodrigo law firm, which I understand is the local one? None. That's what you said at that time. And then I ask you, on what do you advise SMCV? And you say, in this case, I don't know if it's directly with Cerro Verde, but rather with the attorneys for Cerro Verde. Do you see that? Yes. And then we have a similar exchange in which I'm a bit confused as to whether the client is the attorneys or the company, Cerro Verde, and then you explain, and you say, at line 12, let's see, the lawyers of the law firm for Cerro Verde contacted my partners. I understand that was in 2018. And then you provide an explanation, which we'll get into in just a moment. And then I asked you to clarify for me, just for clarification, the Cerro Verde lawyers are who? And you say Debevoise. Do you confirm your testimony? Yes. Now, just to clarify, the contact with the lawyers at Cerro Verde, the international lawyers for Cerro Verde, you take that as a single case because it's the same facts? Yes, but it's for purposes of both arbitrations, correct? I understand that that is the case. And as we just read, the attorneys from Debevoise made contact with your firm as of 2018-2019, correct? I could specify that date on occasion of the last appearance, and actually the date is 2019. Okay. And you also established that since 2019, advisory services were being provided to the attorneys for Cerro Verde and Cerro Verde in general, which entailed facilitating the location of former members of the tax tribunal for them to discuss the exact same thing that they discussed with you, which was regarding their experience at the tax tribunal. Is that correct? Correct. But there I must also add, for on occasion of your question, I checked that with my partners. They were informal calls that were never charged. They were never charged? No. How many calls were they? They were informal calls, 2 or 3, nothing more than that with them. The first contact with me came in September 2020, and it was as of 2021 that charges began. Excuse me, could you say once again when you began charging? 2021. And I understand that as, based on what you said last time, you signed a contract with Debevoise based on your participation in this arbitration. The contract was signed with Cerro Verde. When? In 2021. 2021, not 2020, as you had said before. 2021. What date in 2021? I don't have the exact date, but it was when I agreed to be a witness. You also explained to us that, as from your participation, there were a number of calls with the international lawyers, that there were several conversations regarding your experience in the tax tribunal. Do you confirm your testimony? Yes. And I understand that in those calls, your partners also participated. Yes, particularly in the first part. How much are you charging to participate in this arbitration? It's an hourly fee. I don't have a precise estimate. At the last hearing, you said that you charged more or less $420 or $428. Is that correct? Yes, it is. And you also said that the hourly charge of your partners, Jorge and Ivan, I understand they are your partners, that they charge the half of that. Is that right? Yes, it is. How many? At the last hearing, you said that for your first statement, you had taken about 20 to 26 hours. Do you confirm your testimony? Yes. For drawing up the first witness statement for this case, how many hours did you spend? Well, I have only presented 2 witness statements, and they were presented in both cases, but it's just one statement. In other words, the time that I devoted to it is just what I indicated to you, 20 to 26 hours. When your first statement was submitted in this case, did you have an opportunity to review it? Of course, I signed it. It's identical to the one that was presented in the previous case. Did you review to see if any change had been made? No, it's identical, except for the introductory part. Did you review it? Yes, of course, they're identical. And did you devote 1 hour to it? I don't think so. I just reviewed it to sign it, but let's say 1 hour. Okay. For the second witness statement in the SMC v. Cerro Verde case, you said that you had taken approximately 20 hours. Do you confirm your testimony? Yes. And I understand then that the second statement that was submitted in this case, same situation. Okay. In other words, you signed it, reading it through quickly, and that was that, and then you submitted it. Now, for the hearing in the Cerro Verde case, you told us that you had spent 2 days preparing in New York with the Debevoise lawyers, correct? Correct. How much time have you dedicated to your participation in this hearing? 2 days in Lima. In Lima, 2 days. 2 days? How? Yes. How many hours? From 9 to 5. 7 or 8 hours. For 2 days. Yes. Mr. Estrada, in all, as you had an opportunity to review some points after the last hearing, do you know how much your law firm has charged in all for what? I understand this is 2 witness statements by you. Well, it's really 4, and participating twice in the hearings. How much have you charged in all? I don't have the exact amount. What I do understand clearly are the hours that I have devoted to it, but I don't handle the invoicing. You don't have any idea of a number of hours? Yes. But the total amount, well, one has to do the multiplication to number of hours times hourly charge. Of course, I did a rough calculation, but you can correct me if you think I'm wrong, of your first 2 witness statements. So that's to say 26 plus 20 at $420 yields a total of $20,000, and we'd have to add the 16 hours times 2 of for your participation in the hearings. Correct? Correct. So almost $40,000 it could be. Well, you've done the calculation. I'd have to check it. But if you say so, well, it's already being verified. The attorneys for the other side will be able to correct that if they think it's necessary. Now, Mr. Estrada, just to confirm, in your witness statements, you do not establish anywhere your relationship with Cerro Verde, nor your relationship with the attorneys, nor the payment that you're receiving for being here, correct? Correct. Thank you. If we turn to paragraph 2 of your second witness statement, and I understand that that is at tab 2, though I think you also have them in the small binders. Might be easier for you. Are you there? Yes. You indicate that counsel for Freeport assisted me in preparing this witness statement, correct? Correct. And as I understand, based on the exchange we had at the last hearing, the dynamic was that you would have calls with the claimant's lawyers, then they would send you a draft, you would review the draft, you would make the changes you considered necessary, and then it would go from there. Correct?
Y como establecimos hace un momento.
And as we established a moment ago in the drafting, your partners also participated in drafting those witness statements, Ivan Vera and Jorge Mendoza, correct? Most of the calls, yes. And in your witness statements, you did not establish either that Jorge Mendoza and Ivan Vera participated in the calls that you had with Cerro Verde's lawyers, correct? I do not indicate it. Now I can assume that the words that are contained in the statement are yours? Yes, of course. And I see that you included a number of footnotes. Is it correct to conclude that when you've put footnotes there, you do so in order to provide support for what you're saying in the statement, correct? Correct. When you considered it necessary to include them to support what you're saying, then you did so, correct? Yes. Now let's go to the first paragraph of your first statement, of your second statement, I'm sorry. Yes. You state that you confirm that you have personal knowledge of the facts and matters that you then are to describe, correct? Yes. And in your first witness statement, that's the end of the first paragraph. Let's put it up on the screen. Yes. In your second statement, you added, whenever I testify on subjects beyond my personal knowledge, I identify the source of the information and the basis for my understanding. Correct? Correct. And you confirmed for us at the last hearing that you included this to indicate that there are some issues that go beyond your personal knowledge, correct? Yes.
The documents that you cite to were provided to you by the Vivo's lawyers, right? Yes. Claimant's lawyers? Mm-hmm. Perfect, thank you. Let us now look at your work as a law clerk. In your first witness statement, you say that as a law clerk, you provide assistance to the members of the tax tribunal in resolving the disputes presented by the taxpayers against SUNAT's resolutions, correct? Correct. Just to contextualize this, if SUNAT determined that a taxpayer fails to pay a tax or it pays it insufficiently, the SUNAT issues assessments, that is to say, the determination of penalties. Correct. And the taxpayer may appeal those decisions by SUNAT, first within the SUNAT itself and then to the tax tribunal. Correct? Correct. The decisions by the tax tribunal may be appealed to the courts of Peru. Yes, in a contentious proceeding. That can go up to the Supreme Court of Justice, right? Yes. To be clear, there are 3 instances at the judicial stage. I'm not sure I handle the judicial part of things. Okay, fine. We can talk about that with other experts. No problem. So the tax tribunal solves the controversies between the taxpayer and SUNAT, basically, right? Amongst other administrative things, yes. Those disputes are solved specifically by the specialized chambers, right? Yes. There are cases that can go to the plenary chamber, but specifically specialized chambers are the ones that solve those issues. Yes. Within those specialized chambers, there are 3 members, right? Correct. How many chambers does the tribunal have today? 11. 12, rather. 12. My apologies. I'm sure you know the number better than I do, sir. Once the appeal against the decision by SUNAT comes to the tax tribunal, it is assigned to one of those specialized chambers on the basis of the specialty of each chamber, correct? Correct. And within the chambers, one of the three tax tribunal members is the vocal ponente, correct? Correct. And that vocal ponente, what he or she does is to lead the decision of that project. It prepares a draft of the decision that is discussed with the other tax court members. Yes, with the assistance of a law clerk. The member always works together with a law clerk. So they draft a resolution and it is submitted to the other tax tribunal members. They use a law clerk. The tax tribunal members always use law clerks. That's a rule. Sometimes there are some tax tribunal members that do not use law clerks, but the rule is that they use them. You say a rule. Is it a rule based on regulations? No, it's not in the regulations, but it is in the manual procedures of the tribunal. In your witness statement, you said generally, and now you are given a more definitive answer. Generally. But it is also included in the manual that the member may give the file to a law clerk. I can do it. It can do it, but is there a rule that didn't apply in all cases? So it wasn't always used. In very exceptional cases, in very specific cases, a member did not have the assistance of a law clerk. Okay, very well. You spoke about the procedural manual, and also we have the Manual of Organization and Function of the Tribunal, correct? Correct. And there we have the roles of the different officials within the tax tribunal, as we have in all of the entities where the functions are clearly established, correct? Correct. In that manual, the function of the tax tribunal members is to decide the files assigned to them, to attend the hearings of each one of the chambers where the members issue their votes on the matters in question, and also to have oral reports, amongst other things, correct? Amongst other things, correct? Yes, correct. The Manual of Organization is CA 186. It's behind tab 5. I see that you're trying to look for it. Page 78 of this document indicates what you have said to me in summary form. Is that correct? Yes, that's correct. In connection with the oral reports, the oral reports are hearings, basically speaking, right? Yes. The parties present their cases. SUNAT does so, the taxpayer does so, and the tax tribunal members of the chamber are present there, correct? Yes, correct. I understand that from a regulatory viewpoint, 2 of the members that are going to be deciding the case have to be present during their oral report. Yes, necessarily. Otherwise, a new oral report has to be prepared, correct? Yes, correct. In your written statement, you say at paragraph 28, I think it's your first witness statement. You say that the law clerks tried to be present during the oral reports, correct? Regularly, the law clerks were present, we were present during the oral reports, but not always. If it was a simple case that didn't really require the presence of the law clerk or if was known that they were going to say something that was not novel, the law clerk was not there. But if there were cases that needed more work from the law clerk was always present. When no law clerk was appointed to that case, well, of course, there was no law clerk for the case. So the oral reports can be prepared without a law clerk. That's the exception. But it can be done, yes, of course. But if the members are not present, no oral report can take place. That's right. In this manual of organization and functions of the tax tribunal, and we can show it on the screen if you wish. Yes, please. It's behind tab 5. It's on the screen. Here it talks about, for example, Taxation Specialist 4. That is one of the law clerk levels. What page? Yes, excuse me, I'll tell you the page. It's page 83 of the document. So, Taxation Specialist 4 is one of the kind of law clerk that we have, right? Yes. The functions or the duties are studying requested cases, proposing the solution of the dispute submitted. They have to do research on case law. If asked by the tribunal member, they gather regulations, and also they prepare the draft decision for each one of the files that was assigned to them, correct? Yes, correct. And this you explained in your witness statement at paragraph 29. You mention here what you call the decision stage that takes place after the oral report, correct? Correct. Let's look at paragraph 29 of your first witness statement. We're going to show it on the screen. It says here, first, the law clerk looks at the whole file and meets with the vocal ponente to discuss the decision. Correct? Yes, that's correct. And I'm reading out of your witness statement. Then, after this meeting, the law clerk prepares the draft resolution, the draft decision, which is the draft of the decision. Correct? Correct. And that draft is first examined by the vocal ponente. Yes, that's normally the case. And the vocal ponente may make changes to the draft. Yes, they can do it. Once the vocal ponente is happy with the contents of the draft, it is sent then to the other members of the tax court of the chamber for it to be reviewed. Yes. And those two other tribunal members can, of course, make changes to the draft. Yes, they can do so. The law clerks cannot oppose those changes to the draft resolution. Well, if you're asked, you can justify why you are presenting a certain consideration, but if they insist, you cannot oppose to their statements. Of course. And that draft decision is the subject of deliberation by the 3 tax tribunal members of that chamber, and they decide the case, correct? Yes. In general, during the deliberations amongst the members, the law clerks are not present. Generally, no, but sometimes we are called upon to explain something to the chamber, and we were present, of course. Of course, says the lawyer. The decisions of the Tax Tribunal Specialized Court do not need to be unanimous. No, they can be decided by a majority. If there is a member that disagrees with the resolution, it can issue a dissenting opinion. Yes, they usually do that amongst peers, yes. Of course. And the member that submits a dissenting opinion, does he or she use a law clerk? It depends on the nature of the opinion. Sometimes the vocales issued dissenting opinions in a reiterated manner, and the tribunal had another opinion, so they just copied another opinion, and they didn't really need a law clerk. But if it was very, very short, or if it needed some substantial modification, they used a law clerk. If it was very, very short, rather, they could do it. If it needed more, they used a law clerk. In your two witness statements, sir, you conclude, and you did so during your direct, you conclude that the president of the tribunal and the assistant, I think you call her an asesora now, and unduly included in the decision of the royalty case of 07, 06, and 08 of Cerro Verde. Correct? Correct. Just to confirm, you did not participate in any of those cases, correct? Correct. You did not participate in the oral reports related to those cases. I did not participate in those either. You did not participate in any of the communications amongst the members in connection with those cases. Correct. My conclusion, however, does not have to do with my direct participation. It has to do with the documents I was able to see after being in the tax tribunal for 14 years. Right. You make reference to an email by Ursula Villanueva with Ms. Olano, correct? There are a few emails, I think. Paragraph 40 of your first witness statement. Yes, that's correct. You received that email between 2020 and 2021, right? 2021. And that email was provided to you by claimant's counsel, right? Correct. I understand that claimant's counsel obtained that email via the transparency proceedings. Yes, requests for access to information. Did you verify where the email came from? No. We had already said that this email, like the other ones that you cite, you obtained via the claimant's counsel in 2021. Correct? Correct. Just to set a timeline, as you indicated in our other hearing, the email by Ms. Villanueva was sent before the oral reports that were related to the realty cases of 07 and 08. Before the oral reports, but yes, but before the oral reports as such. Is that correct? Yes. After the oral reports, as we established, there are deliberations on the draft decisions, and in those deliberations, the law clerks are not present. Generally, they are not. At paragraph 47 of your first witness statement, you say that evidence that Ms. Villanueva participated in the case of 2008 was the initials that appear under the signature in the decision, correct? Her initials appear below the signature, and Ms. Olano also recognizes this in her statements. Right. And just to understand, this resolution with these initials, this was served on the taxpayer when the resolution is issued, correct? Correct. The practice, as I understand it, and you explain it, is that below the signatures, you include in capital letters the road, or the work route of who participated in the preparation of the decision, correct? Correct. And the lowercase initials are the ones of the secretary of the chamber. Yes, the administrative secretary. Okay, thank you for the correction. To be clear, the first initials, ZD in this case, are the ones from the vocal ponente, and then you have the rapporteur, which is not the law clerk. Yeah, the rapporteur is not the law clerk. And then, if there is a law clerk, you write the initials. Yes, the initials of the law clerk. From your statement, or your testimony in the last hearing, you not always include the initials of the law clerks, although they may have participated. There are some very rare exceptions. Perhaps a law clerk participated and the initials are not included. Perhaps the draft is so bad that the law clerk had to redo it and the member of the tribunal withdraws the initials of the law clerk. Okay, so including these initials is a practice by the tax tribunal, but it's not the obligation of the tax tribunal. I do not remember any decision without the initials in the 14 years I was there. That was not my question. My question was, it is not a rule, it is not an obligation to include these initials. If you're saying that it's not in the manual, it's not in the manual of procedures, but I do not remember a single resolution without the initials of the work route. Sometimes in the work route, perhaps a law clerk is not mentioned, even though the law clerk participated in it. Correct? Yes, correct. To illustrate this point, if we go to tab 7, excuse me, I do have a comment here, a question rather, just to understand. You said that the initials are there unless the draft is really bad and the draft has to be remade and the initials are withdrawn. When a law clerk participated and, the initials are withdrawn, it's because the work has not been done properly. Perhaps there was no participation also by a law clerk, so there are no initials by the law clerk, but that's in very rare cases. Would it be reasonable to think that internally within the tax tribunal, the fact that the initials are there is like a recognition of the work done by the law clerk? And when the initials are removed is a recognition that the work has not been done properly? In principle, yes. But the idea of the work route is to have the administrative secretary of the chamber to always take the latest version, latest draft, as corrected by the tribunal members. Okay, thank you. Okay, let us move to tab 7. This is RE 258. Let us look at the signature portion of this, the last page. I see that you have it on the screen as well. Yes. You can see the number of the decision, 213-10-2018. And 10 means that it comes from Chamber 10, correct? Yes, correct. And when we look at the signature, first you have G.C. Guarniz Havel. He was the vocal ponente in that case. Yeah, she was. She was the vocal ponente. And then it says T.S., which is the rapporteur, clerk. In this case, Claudia, yes. And then we have Ms. Sagastegi, of course. And then we have the lowercase initials, which are the administrative secretary's initials. Yes, that's correct. In this case, perhaps there was no law clerk. Perhaps there was a law clerk, but he or she was penalized. This is a typical case. Perhaps in cases like this, the tax tribunal member did not use a law clerk. These were very specific cases. Typically, when the decision was very, very simple, very straightforward, this is a case related to payment orders. Payment orders in Peru are only issued on the basis of your own tax return. So the work of a tax tribunal member or a law clerk is only to verify that the amount of the payment order is the same amount in the tax return. So it's very short. Another case where no law clerk was used is when the members that made decisions, well, there were many members in the tax tribunal that had had many years of experience as law clerks of the tax court tribunal. So they knew how to draft this very well. They were very familiar with the drafting of these things. So they could prepare their decisions without using a law clerk. Tab 8, please. This is RE257 for the record. This decision is numbered 124781 2019, and 1 says that it belongs to Chamber 1. Yes, that's correct. Let's look at the signature section, and we have 2 signatures up top. The rapporteur clerk, and then we have the dissenting opinion. Correct? Correct. So in this resolution, we have a 2-to-1 ratio. Not for the full decision. The dissenting opinion has to do with just one aspect of this decision. The initials here, we have 2 types of initials. MV, which is Mariano Valdivia. He is a tax tribunal member. It is under the rapporteur clerk and under the dissenting opinion of Moreno Valdivia, and then the initials of the administrative secretary. Yes, in this case, they didn't include the ones from the secretary of the chamber. Yes, but you said it was part of the custom. Well, what I said is that there shouldn't be a single resolution without a work route. But it sometimes happens, right? Without a work route? No, I've never seen a decision without a work route. The one that you're showing to me has a work route. So the rapporteur did not participate in this decision, or is it incomplete? Is the work route incomplete? Well, the work route came from the latest draft from the folder of Mr. Moreano. That's the capital letters. What about the lowercase letters here? That would be the Administrative Secretary of the Chamber. To be clear, we have three different individuals: the rapporteur clerk, the administrative secretary, and the law clerks. Yes, of course. Their roles are completely different, right? The rapporteur clerk is a lawyer. The administrative secretary is an administrative assistant or executive assistant, I think it is called, and the law clerks, all of us were lawyers. And the decisions should always bear the signature of the three members that made the decision. Yes, necessarily. You say that in the Cerro Verde cases, it is relevant that the decisions were signed because they were going to be signed anyways because of the influence of Ms. Olano, correct? Correct. Your testimony, then, is that the tax tribunal members agreed to sign just to please the president. I don't know if just to please the president, but they signed a decision that was identical to the one issued before, in connection with which they opposed via a series of emails. They said that there was lack of coordination and the issue of Chamber 1, but then they signed this identical decision without any kind of change. Three members did. You're talking about Chamber 10, but in connection with Chamber 1, there were three different tribunal members that signed the resolution that was issued. Those three tribunal members were also under the influence of Ms. Olano. That's why they signed the resolution. Well, the draft decision out of Chamber 1 was worked on by Ursula, and it was also reviewed by Ms. Olano. There was the same kind of pressure that Chamber 10 members had. You did not really live through any of these events. It's not necessary for me to live through them. My question is different. You didn't live through any of these events. To reach my conclusion, I don't have to be present. I concluded what I concluded on the basis of the documents that I was shown and of the 14 years that I was working in that same institution. Sir, please reply to my question. You did not live through any of these events. Again, I wasn't present. I already said that. Thank you.
As we have seen, you also present a series of allegations that are quite serious against President Olano. And you say at paragraph 33 of your first witness statement, we can look at it on the screen. Please go ahead. Towards the end of that paragraph, you say, however, during my time at the tax tribunal, I witnessed how President improperly intervened to influence the resolution of cases of high interest to her with the help of her assistants. Correct? Correct. You do not have any citation to support your assertion, correct? No, it is just my belief. And is that what you saw during 14 years that you were at the tax court tribunal? I don't know if I saw this during 14 years, but I saw this starting a specific year. Did you ever present any claim? No. And you do not either refer to any administrative proceeding against President Olano throughout the 14 years, correct? Correct. Now we move on to the next paragraph of your first witness statement. In there you explain how you believe that there was an intervention in the resolution of the cases, correct? Correct. In the first 5 phrases, you do not cite any document, correct? And then you state that at the same paragraph that Dr. Olano supposedly impacted on the process because she had a lot of power to ratify the vocales. Yes, she was the person who was mainly responsible for it. And you state, I had the impression that the vocales would reject. Could you say that again? In the last phrase of paragraph 34, it should be on the next page. Do you see it? The last phrase. Yes. But you never made any claims against it during your 14 years at the tribunal? No. Mr. Estrada, did you ever participate of the ratification commission as a vocal to be ratified or as a member? I did not, but I was familiar with it because we helped our vocales throughout the process. Just to clarify, in connection with the ratification commission that assesses the vocales that are asking to be ratified, in those sessions, did you ever participate or not? No. Only members of the commission participated of those meetings. And if I recall correctly, in your statement in February, the answer was no, never. Yes, clearly, as a member of the commission or as a vocal to be ratified, but I am familiar with the processes because the vocales always just ask for help. There is a lot of administrative work to be done and documents to be completed, so we did help the vocales. So you were helping the vocales that were trying to get ratified? Yes. Or confirmed? Yes. And you're saying that it required a lot of documentation because it also presented the resolutions and also resumes. Well, in general, the vocal had to present 3 resolutions from the last 3 years, and we searched what we thought were the best resolutions. We discussed them with them, we chose them and together, and then we had more of the administrative portion, document. There was a lot of paperwork. Those 3 resolutions that you look for is because you assess the quality of the resolutions issued, correct? We assess the quality of the resolutions in 2 assessments that are related to the president of the tribunal. Another one is presented by the candidate, and then what the chamber has found about the candidate. And how about those? Do you look for them? Are they randomly selected? Yes, usually we have someone who would do the random selection, and then we analyze the randomly selected resolutions. Fine. Now, on the confirmation commission, you have 4 members, correct? Or ratification commission. Yes, we have the president of the tax tribunal, the dean of the oldest law school of Peru, the dean of the oldest private law school of Peru, and a member of the Ministry of Economy and Finance. And he is the one who has, this member of the ministry has the deciding vote, correct? In case of a tie. Yes, lawyer, yes, correct, because you only have 4 members. Answer, yes, correct. And the deans of those universities, I understand that they are respected universities from the area of law and are very respected individuals, correct? Well, I do not know whether they have specific tax expertise. I do not recall. I do not recall any law dean that has been an expert on taxes. But when you're saying that they are the oldest ones, are they the most important universities in Peru? Yes. Now, if we look at tab 12, CE 667, okay, that document is a document that you cite several times to allege the influence by the president of the tax tribunal, correct? Yes. And this is an interview to a vocal of a vocal to the tax tribunal, Ms. Ana Maria Cogomo. Yes, she was. Yes, correct. She was a vocal. And now this is an interview. If we can look at page 2, question 16. I don't have numbered questions in Spanish. We can put it on the screen. Here, the question is, would you recommend a young professional to join the tax tribunal? Are you there? I'm looking for it.
It's not in his binder. And also, I mean, I think it would be good for him to have the reference.
You're saying that you don't have the complete document?
I'm saying that the complete document is not in his binder, right? I mean, he just said that the numeration is off, so can he...
No, it's not that the numeration is off. The printing, when you print it, unfortunately, the numbers of the questions do not appear. But it's on the screen.
Ya ubiqué la pregunta.
Gracias. Y entiendo que el
I found the question and I understand that the witness found what we are asking him about. The question is, would you recommend a young professional to join the tax tribunal, correct? Yes. And your answer is yes, but. Yes, but. So we can read the but if you want. But it says, but I would tell him that you have to have a calling. Yes. So in general, to work in the public sector, you need to have the vocation for it, correct? A call to that type of work, correct? Yes, that's what I may that answer. If you want, we can continue to read it. So that is the recommendation. It is not just about getting a job. You have to be a good technician and have an interest in public service to be in the tax tribunal, correct? Yes. And if we now look at page 6, I am afraid you will have to count the pages. I apologize. That is the last page of the interview. And the second to last answer to the question that says, take some time. This is an answer that you cite in your witness statement to say that because of the influence of the current tax tribunal on the ratification, on the confirmation process, correct? Yes, this is a question that is highly related to other questions answered by Dr. Cogormo in this case, but I am citing this indicating that she indicated her unhappiness with the ratification process, with the confirmation process. You said, take some time to think about your new occupations, and many people look to you as an example. And she says, I would like to teach and be a consultant now, correct? Yes. And then she said, it's great to be absolutely free and not to be wondering if there will be confirmations or not, whether they liked it or not. And then she continues, and you quote, and you're saying, but I'm happy all the same, and I'm very grateful to the tax tribunal for all that time because I learned a lot and I met very valuable people, correct? Yes. She's happy to leave the institution. She's thanking the institution. When one reads that answer and reads that with the previous answers to this question, the deepest question by Dr. Cogormo had to do with the pressure at the time of confirming a vocal. So she's happy. She doesn't need to be part of a process that she thought was completely unfair and unnecessary. Every 3 years. First of all, she does not use the words unfair, correct? If we look at a previous question, she does not say unfair, but she says that it is a pressure mechanism. You can look at this later on with your attorney, but it says, I am happy, and she thanks the tribunal, correct? But I think that she's thanking because she's happy because she's leaving, and she is thanking for her time. She learned very valuable people and the time. I do not think she's thanking the institution, just the time she was there and also the people that she met while being there. Yes, because she appreciates whoever she met. So she thinks that they were very valuable. So in this interview, Mr. Estrada, Dr. Cogormo does not mention the president at any time, correct? Well, there are no more than 2 presidents. There is only one. So when she questions the position of the tax tribunal president, she does not mention Dr. Olano directly, but clearly Dr. Olano was the president back then. And just to confirm, in spite of all of these alleged issues that Ms. Cogormo had, she recommended a young person, correct? Yes, but also with a caveat that the person needs to have the vocation to do it. And she thanks again. She thanked. I don't think that she's thanking the institution. Dr. Cogormo, did she ever put a claim against Dr. Olano? Well, I think that she is expressing her dislikes, but I don't think that the vocales could offer any interviews. That's why I'm asking you about Dr. Cogorno. When she left, did she present any claims? I do not recall anything beyond this interview, but in this interview she criticizes. Mr. Estrada, in your second witness statement, I think that you do it in both, but in the second one you referred to
hubo un cambio de cultura
a culture change when allegedly there was a change in the tradition when 1115 was passed for a bonus on the performance on the vocales. Can you show me that? Yes, this will be paragraph 15 of your second statement. Do you say second? Yes.
¿Está ahí?
Sí.
Are you there? Yes. There it refers to the efficiency or the performance bonus. And at that paragraph, you also say that that bonus was never implemented. Yes, that's why it was a negative incentive since it was never implemented. Mr. Strada, the 1115 decree says that there is an authorization to pay the bonus. Here it is saying that it will be regulated through the Ministry of Economy and authorizing the MEF to grant that bonus. And here it says clearly that it had to be authorized by the MEF. Answer, well, this goes back to a supreme decree that was never issued. That's why it was so perverse, so negative. But if the legislative decree only says do it, you cannot wait until it is actually regulated to be paid. Whenever a law issues or goes back to a regulation or a law of a lower hierarchy, that law has to exist. The exception is what happened in this case. That is, that the Ministry of Economy in 2013, 2014 and onward did not regulate, did not implement the bonuses, but that was a perverse aspect of these bonuses, because the only reason why a Ministry of Economy and Finance is not regulating resources is because, or is not regulating these expenses, is because they do not have the resources. So the idea here was for them to stop with the excuse of not paying the bonuses due to lack of resources. If they had implemented this bonus, it would have been less detrimental than the fact that it was not regulated. But the truth is that it was never regulated. Correct. It could never be expected to be paid. But once again, you need to wait for a regulation that refers back to another one to be regulated, to be actually regulated. And this is not ordinary, and this is what led to this incentive that was detrimental. I imagine that the vocales must have tried to change their regulation, but there was a great expectation in the first 2 to 3 years, meaning that it was going to be regulated.
I have no further questions.
Gracias. Thank you very much. Any questions in redirect?
Yes, we do have several. We would be grateful.
Several.
Yes, we would be grateful if we could break for lunch, and then come back and we can do the redirect, Madam President.
Yeah, we would prefer the questions now. Just in order to, now for the further planning, we have to end the hearing today at 5:30 in time. And I think Mr. Izazi is waiting on his remote testimony. So how much time do you need for your questions? What?
I hope to be I hope to be brief, Madam President. Hopefully 10-15 minutes.
Then we would like to conclude.
Okay, could we have 3 minutes just
Sure.
to? Okay.
Sure.
Thank you.
So we continue with the redirect.
Thank you, Madam President. Yes, we're ready. I'll switch to Spanish again.
As you heard, we are short of time, so I am going to ask you some questions about your statement, and the questions by the attorney on behalf of Peru. Please respond as briefly but as specifically as possible. Very well. Peru's counsel mentioned that you were not in attendance. Rather, you did not participate in the resolution of files for the 2006, 7, and 8 royalty cases. Do you recall that? Yes. And you said that you did not need to be present to offer your statement on the irregularities that were presented at the tax tribunal in this specific case. Correct. My colleague showed you the email that you referred to indicate the irregularities. This is the email that Ursula Villanueva sent to the president. Do you recall that? Yes. My question here is, do you think that this is a familiar email, or why is it that you can identify this email based on your experience? Could you please show the email on the screen? I think it is in your statement. Yes, I have it here. Based on your experience, as you mentioned, this type of, what type of email was this? Did you usually see it? Well, this is a typical type of communication between a law clerk and the vocal ponente. From this point, I must have sent 50 emails like this one to a vocal I was working with. This is an email for coordination purposes, and it is not only recognized by Ms. Olano in her statement, but it is also signed by Ursula Villanueva. It is typical when a law clerk has reviewed the file, and in this case, Ursula Villanueva, she said, I sent you the file for both parties, as well as the main clauses of the stability contract that is related to all of the disputes, Cerro Verde dispute. There are arguments that go both ways. She has a position, and I am favoring one side rather than the other. And when she says, when you can read the arguments and we can discuss it, this is typical, sent for the deliberation of a new file, and is sent by the law clerk to the vocal ponente. Thank you. You were also asked about irregularities that you witnessed. What types of irregularities, briefly, did you witness? When did you start seeing them? As of 2012 and up to, or between 2004 and 2012, when I was with the tax tribunal, the workload increased significantly, but the chamber would usually resolve these files based on the oldest one presented. Then there was a new administration in Peru. We started to see news indicating that there was a large amount of money that it was being litigated at the tax tribunal. So starting then, Ms. Olano started to send some information and some lists that included the files of the tribunal, that included from the highest to the lowest amounts, but they broke away from this principle to resolve the issues based on seniority or the oldest cases presented. That continued, that initiated in 2012 and continued. So was Cerro Verde part of this list? Yes. So if I understand you correctly, Cerro Verde was included in this list because of the amount? Yes, because of the amount that was being in dispute before the tax tribunal.
In addition, my colleague took you to a document that is to say the lawyer for the other party, took you to the document at tab 12, which is the interview with Ms. Corono. Ms. Coborno was a member of the tribunal who served as a member of the tax tribunal for about 20 years. She was the presiding member of Chamber 1 when I came in. She retired because she hit the age limit. When did she retire? Do you remember? I don't remember exactly, but it must have been about 2013. Now, the next page at the top is the question that begins, what is your opinion about ratification of the members of the tribunal? Oh, all right. It seems to me this is one of the questions that you were referring to in your response. Could you explain more or less what Ms. Coborno is saying here? It's question number 32. Could you read the question, please? What is your opinion of the ratification of the members? It seems to me a bad idea that they ratify the members. It's a form of indirect pressure. There are sufficient grounds for removal in the tax code because ratification may be impartial or a means of pressuring, even more so now that it has to be done every 3 years. So here, Ms. Coborno is saying that it is a means for bringing pressure to bear. Did you hear this from other members?
Is that a leading question, asking if he heard this from other vocales?
Your previous question was...
Okay. Sorry. I'll just rephrase the question again. ¿Usted escuchó?
Did you hear what Ms. Coborno said, that it was a way of bringing pressure to bear on the other members? Yes, there's no member who wants to be ratified every 3 years, especially because the criteria for ratifying the members of the tribunal, well, there were objective criteria such as their CV, a psychological evaluation, but those two components accounted for only 10 or 20%. The lion's share of the criteria for ratification, 60%, depended entirely on Ms. Olano. And can you read the next question that begins, do you trust the ratification commissions? And could you read the question first, please? Do you trust the ratification commissions? And her answer is, I don't know what the criteria are under which each of the members of the commissions acts. I would prefer to have the Ministry of Economy and Finance make changes based on the grounds of the tax code. So is she saying she trusts? No, no one trusts the ratification commissions. What they wanted, the tax code, had specific grounds for removal of a member of the tribunal. So a ratification process, when you had not engaged in any of the grounds, were a political pressure with respect to how they would act. Thank you very much. And the colleague from the other party also mentioned the bonds, or the bonuses rather. This was an expectation. If we could turn to question 56 of this article. It's the next to the last question. It begins with bad things. What are you referring to? Could we begin on the last page, or rather the last word of that page, where it begins with the word tampoco? Bad things, what do you mean? Nor have they, neither have they paid us the bonus created by Legislative Decree 1115, which had to be paid on a quarterly basis according to that rule. From July 2012 onwards to this date, the Supreme Regulatory Decree has not been issued, and that's why they aren't paying. In any case, they owe it to me as from July of 2012. So it was an expectation. All of the members evidently expected it. Now, moving on to another topic. These irregularities that you witnessed in the tax tribunal, that you mentioned in answering the lawyer's questions from the other party, she spoke of the deliberation and decision-making process within the tax tribunal. When irregularities such as this came up on the part of President Olano, was there any possibility of a discussion or deliberation, that is to say, or contrary votes? Well, as I told the attorney, Mr. Moreano was always with his peers. When a draft had been prepared upon by the president, then that diminished that possibility. I never saw a dissenting vote when Villanueva had worked up the draft. So what was the capacity for deliberation? Well, this is a draft decision from the boss. It's difficult to oppose that when that same year or the next year you're to be ratified. Now, you mentioned Mr. Moreano. Mr. Moreno was bothered upon receiving this draft, the draft from Chamber 1. Mr. Moreano was upset. Why was Mr. Moreano upset?
A specific resolution from Moreano. So I'm asking the question about Moreano, and also you asked him about the resolution process. So this is a question about the resolution process. I'm sorry, it is. I'm just asking about...
No, you're asking about the coordination.
I'm asking about the Chamber 10. Okay, thank you. Perdón, voy a hacer un poco...
Excuse me, I'm going to try to speak a little more slowly. You mentioned... What mention was made of the deliberative process in Chamber 10, or the deliberative process in general. Yes. Also mention was made of a decision by Member Moreano. When you speak of Mr. Moreano, and you're also talking about this decision process, why do you believe that Mr. Moreano was upset for having received a decision that already resolved a matter that was before their chamber? Shouldn't he be happy that a complex case was already resolved? Well, not actually. What should have happened at the tax tribunal, and what was done when the chambers had either the same case or very similar cases, they should coordinate first before issuing even a draft. What would happen, in fact, would be that one would advise a law clerk, or rather name law clerks from Chambers 10 and 1, and then they would sit down together and we would begin discussing with our members that matter. The Moreano was upset not because the work had been done for him, but rather because he did his work in vain. Let us recall that the matter before Chamber 10 had an oral report 1 month before the one before Chamber 1. Normally in the chambers, when it is submitted for oral report and there's a draft, because there needs to be something to show the members when the parties present their arguments so that the members have knowledge of the case that is being presented, the vocal ponente presents an initial draft. Now, the fact that Chamber 1, with no coordination, had issued the decision, because that's what the complaint is about, not that they're working, but that the decision was issued, then they throw out all the work that Chamber 10 had done in this case. Very briefly, Mr. Estrada. Now, answering the questions by Peru's lawyers, you spoke about the work of the law clerks. Why do you think it was unlikely that Member Cayo had worked on this matter without a law clerk? And I'm talking about the matter regarding the 2006-2000 royalties. I don't think it's unlikely. I think it's impossible for him to work on it alone. Mr. Cayo, all the time I was in Chamber 10, I worked with him. Mr. Cayo came into the tax tribunal, but his only expertise was that he was an accountant. He obtained his law degree the same year that he came into the tax tribunal. As an accountant, well, accountants have many difficulties when it comes to writing, particularly such complex or technical writing as the tax tribunal has to do. So Mr. Cayo, in the cases that were much simpler than this, in really any case, he would always turn to a law clerk. The Cerro Verde matter was a particularly complex one. It was a controversy that had not been decided by the tax tribunal. It was a very voluminous case. I knew that because I handled it. It involved about 5 volumes. Each volume has 500 pages, and the controversy involved a significant amount. So it's impossible for him to have worked on it alone unless he took the decision or the record from Chamber 1 and then just copied it and adjusted the data. Thank you very much.
Thank you. A question on recross?
Unfortunately, yes, Madam President. I will be very brief.
Mr. Estrada, you say in response to one of the questions put by the lawyer for the company that as of 2012, the culture of the tax tribunal changed, right? In terms of resolving the matters on a first-come, first-served basis. You left in 2018, correct? Correct. For 6 years, did you denounce, during those 6 years, did you denounce any of the irregularities that you're discussing here? No, I was a law clerk for a chamber. It's the member who is most prejudiced by the conditions. I would do what the member would ask me to. But you saw irregularities and you did not denounce them to anyone? The irregularities did not involve me. They didn't involve my work. So I did not. Now, you spoke about the ratification process with the lawyer for Freeport. If we could, and you spoke of the percentages, scores that were assigned to the members who were seeking ratification. If we could turn to tab 11, please. And for the record, that is Exhibit CA 232. And if you can turn to Article 17, please. I'm there. You're there? Article 17, you're there? Yes. There's a table that shows the scores, and it speaks of CV, quality evaluation, evaluation of effectiveness and efficiency, and the psychological evaluation, and there's a personal interview. And I'm told there's no interpretation, there's no translation of this document, so for which I apologize.
So I will read it in Spanish.
So it shows the different scores for the different criteria that are the basis for evaluation of the members, correct? Correct. The quality evaluation has a 30% weight, correct? Yes. Now, if we can look at or turn to Article 22, and I'm so sorry because there's no translation for this either. Are you there? It says, at 22.1, it says, at the meeting called by the President of the Commission, each member thereof shall evaluate and grade based on the conscience and exercising the principle of freely evaluating the CVs of the specialized chamber members, the quality of the decisions, and it's noted that some are chosen randomly, presented by the members and provided by the President of the Tribunal, but it's through that random process, correct? There are two aspects where the President of the Tax Tribunal steps in. No, but that's not my question. To answer your question, I need to tell you that she prepares two reports. One for the quality evaluation. A report is done on the decisions proposed by the members, and in terms of effectiveness and efficiency, a report is drawn up on the decisions that have been randomly chosen by those members who are subject to ratification. And if we look at 22.2, it says for evaluating quality, the Commission may draw on the services of a specialized third person, correct? Correct. Those decisions can be turned over to a third person to independently evaluate the quality of the decisions. Now, in all the years I've been at the Tax Tribunal, and I've seen many ratification processes of the members I work with, the only third party who would be brought in from the outside was a notary who would choose the decisions. I've never seen them call in a third person to evaluate the quality of those decisions. But it's in the rule. It is in the rules of power, but I've not known of them to have exercised it. Now, you spoke about the email from Mr. Moreano, and you said what Mr. Moreano meant to say there. Did you speak with Mr. Moreano about what he meant to say? We can read what it says. It's not necessary to interpret what it says. He says it's clear what he says. No, that's not my question.
So if you're asking about the email, it's just fair that you show him the email.
Madam President, I am not asking about the email. My question is simply if he talked to Vocal Boreano about that email.
So which email? So you're referring to an email, so he should have the document available.
You asked him in redirect about an email. He knows perfectly well what email I'm talking about.
Sorry, there were various emails, so which one are you talking about?
I will rephrase my question. Señor Estrada,
Mr. Estrada, did you speak with Mr. Moreano about correspondence or emails that he's written? This email? No. But we would always discuss any correspondence that Mr. Moreano would have issued. He was my boss for several years. But you did not discuss this email with him? No. Now, you make a number of assertions that 6 members, including your former boss, Mr. Moreano, signed because the decision came from the president of the tribunal. Did you at any time denounce them for having signed something that they had not decided? I have only learned that they signed something that they did not write on occasion of this arbitration. I did not know that when I was at the tax tribunal.
Thank you very much. As the tribunal has no... Oh, do you want... So we do not have any questions to you, so you are released as a witness. Thank you so much. Let us now discuss the afternoon. Our next witness will be Mr. Herrera, right? And then, so can the parties already estimate how long this will take? Do we need to inform Mr. Izazi or?
Madam President, I will be doing the cross-examination of Mr. Herrera, but I having not initiated the cross-examination and nor heard his answers, I can't say exactly how long. I don't necessarily anticipate it being ideally more than an hour and a half.
Mm-hmm. Okay.
So
you keep Mr. Izazi informed.
Yes.
So he would be at our disposal. And what about we could shorten the lunch break? If the parties agree, then we could resume already at 2. Would this be an option?
Yes, we're in your hands.
Okay, then we will do so. See you at 2.